Hello everyone and welcome back to the channel. This is Snigdha Mohapatra, a third year student of KIT School of Law and currently an intern under LEXCLIQ. In the previous video of mine, I had talked about winding up of a company and the different modes of winding up and the grounds under which a tribunal may order for winding up of a company. In this video, I will be talking about who can make a petition for winding up of a company. This has been mentioned in Section 272 of the Companies Act. A petition for the compulsory winding up of a company may be presented by the company or any contributory or contributories or all or any of the persons specified above or the registrar or any person authorized by the central government in this behalf or in a case falling under clause B of section 271 by the central government or a state government. Now, I will be dealing with each of these in a brief manner. Now, the first comes the company. A company may make a petition for its winding up when the members of the company have so resolved by passing a special resolution. However, it is not very common for companies to apply for winding up order since if desired they have only to pass a special resolution for voluntary winding up under section 304 of the act. But where the directors find the company to be insolvent due to circumstances which ought to be investigated by the tribunal, they may file a petition for winding up order on behalf of the company. In such circumstances, a director may make a petition even without obtaining the sanction of the general meeting of the company. This was held in the case of State of Madras versus Madras Electricity Tramway. A company whose name was not in the register of companies was not entitled to file for a winding up petition. In the case of Anubhav Gupta versus Inside Softwares Limited, the name of the company had been struck off from the register of companies due to non-maintenance of various records and statutory registers. The company, instead of seeking restoration of name in the register of companies under section 252, filed a petition for winding up under section 271. It was held that, that the name of the company was not in register and hence it was not entitled to file a winding up petition. Now, secondly, a contributory or contributories petition can be made in the tribunal for winding up. A contributory means any person liable to contribute to the assets of a company in the event of its being wound up under section 2 subsection 26. Except for this purpose, the term contributory includes a holder of fully paid shares. A contributory, however, may petition on any other ground if the shares in respect of which he is a contributory or some of them were originally allotted to him or have been held by him and registered in his name for at least 6 out of the 18 months preceding the commencement of the winding up or have devoted upon him through the death of the former holder. A contributory shall be entitled to present a petition for winding up of a company, notwithstanding that he may be the holder of fully paid up shares, or that the company may have no assets at all, or may have no surplus assets left for distribution among the shareholders after the satisfaction of the liabilities. This position presumably stems from the proposition that a shareholder, as such, has a stake in the affairs of the company, irrespective of whether he is holder of fully paid up shares or not. However, the tribunal has complete discretion whether to order winding up or on taking totality of circumstances into account. It has also been seen that holder of forfeited shares and a legal representative, that is, a legal representative of a deceased shareholder, is a contributory for the purpose of section 272. Now, the Andhra Pradesh High Court in Coromandel International Limited versus Chemical Biotech Limited has ruled that power granted by the petitioner company to its authorized representative for filing suits or proceedings for recovery of amount does not cover power to institute winding up proceedings. Now, a third person who can file for petition is a joint petition, that is, by all or any of the parties specified in subsection 1. This means that any combination of the company and the contributories can present a petition for binding up. Now, the fourth person who can file for a petition is the registrar. The registrar may file a petition on any ground mentioned in section 271 except grounds specified in clause A. Hence, a petition by the registrar can be filed on the following grounds. Firstly, company acted against the interest of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, or decency or morality. Secondly, affairs of the company have been conducted in a fraudulent manner, or the company was formed for a fraudulent and unlawful purpose, or the persons concerned in the formation or management of the company have been guilty of fraud or misfeasance or misconduct in connection therewith. Thirdly, default by the company in filling with the registrar its financial statements or annual returns for immediately preceding 5 consecutive financial years, or if it is just and equitable that the company should be wound up. Before making a petition, due to inability of the company to pay its debts, it must appear to the registrar that the company is not able to pay its debts. For this, the registrar will rely on the scrutiny of the balance sheet filed by the company or from the report of an inspector appointed under Section 210 of the Companies Act. The registrar cannot present the petition unless sanctioned by the central government. The central government shall give its approval only after an opportunity of being heard has been given to the company. Further, such petition must be filed within a reasonable time of the obtaining sanction, failing which the court or the tribunal shall not recognize the sanction as valid. Now, fifthly, any person authorized by the central government can file for a winding up petition. This also the central government or state governments can file for a winding up petition. The central government may petition for winding up where it appears from the report of inspectors appointed to investigate the affairs of a company under section 213 on the grounds that it is just and equitable that the company should be wound up. The government may authorize any person to act on its behalf or the purpose including the registrar. The central government of or the concerned state government is empowered to file petition for winding up on the ground contained in section 271 subsection B, that is company acting against sovereignty integrity of India, which has been specified before and I have talked about in the previous part of this video. Thank you so much for watching the video and hope you are benefited from the video. Please subscribe to the channel for regular updates and comment and share. Thank you so much.